For staying with us once again. Our conversation for today is on Nnamdi Kanu's terrorism conviction. The court spoke yesterday and loudly at that by convicting and sentencing the IPOD leader Nnamdi Kanu to life imprisonment after years of legal firework. Reaction is already trailing the judgment of Justice James Omotosho, who convicted him on all 7-count charge of terrorism. How are Nigerians perceiving this judgment, and what are the legal implications of what transpired in court yesterday? We have those who should know when it comes to the law. We have Barrister Gabriel Uduafi. He's a legal practitioner. It's a pleasure to have you.
It's good to join this morning.
And we also have former Secretary, NBA Ikeja Branch, Adeyemi Abijo. I hope I got that right.
Very well, Abijo. Yeah.
Okay, we also what transpired yesterday during that court proceeding, the behavior of Nnamdi Kanu, and of course how Justice James Omotosho was able to manage his unruly behavior. But looking at it legally now, what do you make of that judgment of yesterday? Let me start with you.
Well, first of all, I think being a lawyer and somebody who goes to court regularly, I've had the honor of appearing before judges from the trial court to the Court of Appeal and to the Supreme Court. And I particularly give credit to Justice Omotosho. He's a judge I've had cause to appear before, both in Port Harcourt and in Abuja, sitting as a federal high court judge. And I salute his temperament all through the process, from when the team of lawyers for Kanu withdrew their appearance from one court proceedings to the other, the disruptive attitude of Kanu during the entire proceedings, and even when he expressly confronted, times without number, the judge, and telling the judge, even to the glare of the cameras, that the judge does not know the law. But now was still able to put himself together, didn't lose his composure, and still did what he had to do as the law requires. The details of the judgment, of course, is not yet out, but a lot of people listen to the proceedings on television, and we hope to be able to get a copy of the judgment and read what it's contained herein. But as it is, speaking from a legal perspective, I would say that, look, when Kanu decided not to offer any defense in respect of the serious allegations of crime that were made against him, whether rightly or wrongly, he left himself open for a very serious legal defeat, particularly when your team of lawyers, led by no less a legal personality like Kanu Agabi, had argued that you had no case to answer, and the court found against that argument that at least there are issues that arose from the prosecution's case that require your explanation. That is what is called come and make a defense. There are a prima facie case has been made against you. Please come rebut this evidence. But he said he was not going to do so. He would rather challenge the powers of the court to try him. According to him, that his offense is not known to Nigerian law. And all of that. And what he was insisted on doing is filing a written argument. Speaking as lawyers, I'm sure my colleague would also understand that your legal argument does not have a leg to stand on if you don't provide the evidential materials on which to anchor your legal argument. No matter how swift or beautiful or sweet your legal argument is, you write better than Shakespeare in legal arguments. If there are no evidential materials on which to anchor your legal argument, of course, they go to no issue. And in legal jurisprudence, both criminal and civil, your argument does not really do much as to sway the mind of the court from the facts that have been established through evidence. That is why even at the Supreme Court can disregard your brief of argument and still go ahead and determine the substance of the case against presented by the parties on the basis of the arguments that have been tendered. These are legal, and that is why you always require the guidance of a lawyer, and that is why the law insists that if a person is charged on a criminal charge and he does not have even the capacity to retain a lawyer, the court has a duty to tell him that you have this responsibility, and when you accept the court can even direct public litigation institutions to come and defend you, like the Office of the Public Defender in Lagos, like the other institution established by the federal government, so that you have a legal representation to make your case. But he opted against all of these legal and constitutional safeguards, and he decided to jump into the sea without a life jacket, if you ask me.
Okay, Adeyemi, all beyond perspective.
Well, not very far from, what has been said by my learned colleague here. One would wonder, first and foremost, as a lawyer, you want to wonder what was the strategy behind sacking all of
his lawyers.
And not considering the fact that he had one of the best, in the legal profession. The Dana Silk Kanu Agabi, in the first place, wouldn't even have accepted such a brief if he didn't understand or believe in the case of Kanu, Nnamdi Kanu. So for him to have accepted such a brief and have taken steps to the extent of filing what we call a no-case submission. A no-case submission in law means that I am saying that all the evidence that you have presented before the court has not sufficiently proven that I am guilty.
Okay.
And that I do not even need to come and explain myself by way of presenting evidence. But the court ruled against it. If the court had ruled against it, it does not in itself, in law, mean that you are guilty.
Okay.
What it only means is that you are given the opportunity to come and also present your own evidence to counter what has been presented before the court.
Okay.
And then at the end of the day, you may eventually be acquitted.
So are you saying that when we all listened to the judgment yesterday, was it something you were expecting due to how Kanu has been, presenting his case or his behavior throughout, the court proceedings?
Very, very much. For lawyers, for legal professionals, as at yesterday, all we were waiting for was let the judge take, what do you call it? The last bite, that is the judgment.
Okay.
First and foremost, you had all of the opportunities in the world.
Okay.
Constitutional opportunities that you have been presented to defend yourself.
Yeah.
You not only sacked your lawyers, you even opted not to present, any defense. What more do you expect from the court? And lastly, you went ahead to attempt to arrest the judgment by way of filing, some sort of, court processes at the Court of Appeal, at the court, in fact, at the Court of First Instance in itself. The court was wise enough to have gone ahead to first and foremost deal with such areas, because the major challenge that court could have had is not to have pronounced on those steps that they are taking. Okay. Stay of proceedings. Okay. Good enough. The law had seen that, or do I say that had been taken care of in the laws of the land. The Administration of Criminal Justice Act, which affects the proceedings in court has said it very clearly. I think section 306, to be specific, that courts do not need to stay proceedings any longer in criminal, trials, because what that will do is that it will needlessly prolong criminal trials. So you go here, you come back again, and court has said nothing like that. At best, a judgment has been handed down. You now have the opportunity again. You have the constitutional, right to appeal against whatever the court has said in its judgment. So that's the court.
But it seemed already said they were going to appeal yesterday.
That is the right he has.
Okay, talking about appeal, just this morning we read that the Deputy Speaker of the House of Representatives, Right Honorable Benjamin Ikeja Branch, expressed optimism that the leader of the indigenous peoples of Biafra, Nnamdi Kanu, will be freed through a political approach. I need clarity on that.
You're asking me that.
I'm asking you.
I'm one of the politicians.
What does that even mean?
Okay. I think that I like for us to have an organized discussion about this Kanu's travail, whether you are on the side of those who support him or are sympathetic to him, or on the side of those who say no man is bigger than the law. I am an advocate of the fact that no man is bigger than the law.
The law is the law.
When Obafemi Awolowo was also undergoing a trial for treason, for which he was sentenced, a lot of us have read that beautiful allocution. And a lot of us also forget the fact that Obafemi Awolowo was a trained lawyer and a senior advocate of Nigeria. But even at that, during the entire court trial, he conducted himself well. He had lawyers to defend him, even when he is a lawyer. My friend will attest to the fact that several senior advocates of Nigeria in recent time, here in this country, particularly in this Lagos, have been charged to courts. No less a president of the Nigerian Bar Association, a city president of the Nigerian Bar Association, was charged to court in this country. I would not mention the name, He didn't say because I am a sitting president of the Nigerian Bar Association, I would not retain the services of lawyers to defend me. He did. And that senior advocate of Nigeria was also charged before a high court in Lagos here for charges of corruption or influencing the decisions of a judge. A senior advocate of Nigeria also recruited the services of senior advocates of Nigeria to enter into his defense. In fact, he was convicted in Lagos. He served his prison sentence in the Kirikiri Correctional Center. His conviction was affirmed by the Court of Appeal. It was only the Supreme Court on procedural grounds, through the argument of one of the lawyers that Kanu sacked, that got him out on procedural grounds. So I didn't see the wisdom in those who were singing the praise of Nnamdi Kanu that he was doing the right thing. Now, his appeal is just left to be decided on the basis of the evidence which the judge was presented to the judge, his conduct, which the judge also recorded in the course of delivering the judgment. There is no rebuttal evidence on the other side. Even if it's for civil proceedings, we say you weigh the evidence on the balance of probability. Now, we are putting the scale, and there is nothing to put on this other side. But you know what that means. For those of you who go to the market, and so you understand that it will just sit. But for political solution, a lot of some of these issues eventually, like what the president did in exercise of his prerogative of mercy, has also let some people off in that exercise of his prerogative of mercy. And for adopting a political solution as well will mean that Kanu will eventually be granted clemency, which is going to essentially lead to the invocation of the powers of the president for prerogative of mercy, depending on how the issues will be presented. That will now be a political leeway for him. But for the legal issue, I don't know whether even the lawyers that were acting as consultant, who also have been facing some challenges in court over their conduct in this issue, have really divested themselves of their personal involvement in this matter as to be able to come up with credible and viable grounds of appeal to challenge the reasoning of the courts at trial. So at the end of the day, maybe, just maybe, it will just be, okay, let's find a political way out, let him be granted clemency, then let him be told to go and sin no more, because it's never going to be conditional, because even after his conviction, he was still very, very unruly. So even when the court even wants to grant you on bail, court grants you on bail on the condition that you will be of good conduct and not revert back to the status quo that made you came to court. So we have a lot of issues. I think he needs to get psychologists to speak to him, so that whatever grievance that you have, you may be able to calm yourself down, and be able to face the reality. The reality of Kanu's situation today is that he is a convict, who the court has said, by reason of his conduct and display in court, he cannot even be kept with regular inmates. That special provisions will need to be put for the safeguard of. So his case is not just a conviction. It's a special case. It's a special case.
Okay, Adeyemi, part of what the judge said yesterday was also the fact that he must not have access to any digital device. And while handing over that sentence yesterday, counts 1, 2, 4, 5, and 6 opting for life imprisonment instead of death sentence. That's according to Justice Omotosho. The judge also handed Kanu a 20-year jail term on count 3 with no option of fine, and a 5-year jail term on count 7 with no option of fine. Justice Omotosho, after convicting Kanu on a 7-count charge of terrorism, and the 7-count charge against Kanu relates to secessionist, agitation, act of terrorism, membership of a proscribed group, killing of security operatives, destruction of public property, concealment, and importation of an unregistered radio transmitter. Looking at that judgment, was it too harsh? Going by the breakdown of this count charge.
Very well, thank you. Well, first and foremost, the judgment was not harsh, let alone, relate to it as too harsh. The judgment was not. In fact, from what you have read now as part of the judgment, the legal community, there's a conversation even going on.
Because some people in the South East are already saying that, so they preempted what the judgment will be, that they were not surprised.
They never did. The judge opted to give life imprisonment when indeed
instead of death sentence.
Like I said, in the legal community, there's a conversation about that. Of course, in a lot of ways, judges have, liberty to decide which way to go in some, circumstances. For example, option of fine. The laws sometimes also allows for either the fine and imprisonment, or one or the other. So in this case, if you look at the entire gamut of that judgment, what you will find is simply a judgment that is, I don't know how to, put it. It's not harsh in any way. In fact, some of the reasoning of the court will be based on the attitude of the defendant, especially when you are, dealing with bail, when you are dealing with judgment in criminal matters. Now look at the attitude of Nnamdi Kanu from the commencement of trial, whether at this very court or at the different courts or judges before whom he had appeared. He has consistently been unruly. In fact, yesterday live I was listening from the radio transmitter all that transpired, especially up to the point when the judge was appealing to him. Just to underscore my colleague's position as to the temperament of the judge. Of course, that is a part of the training.
Okay.
To be a judge, you must also have that temperament that gives you authority over your court, and you must not use it. You must use it judiciously, and you must use it very well, so to speak. So, he had exhibited so much violence, so much tendencies to make a judge get to the point of, please take this man
out of the court
first. And of course, the law allows for his absence. One of the grounds for which the law will allow his absence in a trial is his conduct. And he has exhibited so much of that the judge had to come to the point of, take this man out. And then after judgment, we could also see. So why on earth would anybody come to think that that judgment was harsh? No. In fact, at some point, maybe about a month, 2 or 3 ago, when the issue of political solution was being, put forward all about, there were some people in the Southeast who came on air to say that, what do you mean political solution? That our family members had been killed as a result of his actions and activities,
his directives.
Our children have been killed, our fathers have been killed, our grandfathers have been, and we have not even been able to get closure. These are people who, each time they hear the name of Nnamdi Kanu, what comes to their head is the people that they have lost. So crime haven't been committed. What more can the state do?
Consequences for crime.
And the state has done, what the state has done is that they have allowed him all of the constitutionally guaranteed rights. And of course, this conviction does not also stop the constitutionally guaranteed rights to also appeal. Court of Appeal, Supreme Court. So it means that one day he may be free. He may be free. So in conclusion, I will just simply want to advise, the naysayers in court, that what has happened is that the law has taken its course. Let them also follow through with the law. Political solution is a difficult situation in his own circumstance. Because for you to consider a political solution, then you must have conditions attached to it. Is it with somebody who is this unruly? Somebody who all he needs to say is to say, Mr. President, you are you are psychologically.
He even told the Justice Omotoso that he was saying rubbish.
I didn't want to go to that. That's why sum it up as saying he has been so unruly before a court of law. Even lawyers, there are things you cannot do before a judge. Even calling when you are before a judge, you cannot even refer to a judge as you.
As you, yeah.
Not because he is the person, but he is the law.
At that point in time.
So and you could hear Justice Omotoso was when he was taken out, and Justice Omotoso was going to continue the proceedings. He said some things about the sanctity of the court,
the temple.
So he wasn't talking about himself. He was talking about that thing that even as lawyers we see as the mystery of the profession and the work they do as judges. You can imagine how much he had to analyze the evidence, the arguments, A, B, C, and all of that for a judge. Even for us, some of us would not even, I would not take it for free to be a judge, because they will bring all sorts of things before you.
And you have to read it.
You have a duty to analyze. In fact, the fear yesterday for him too was that, will I be able to do justice on this matter at the end of the day, especially when the entire public expects. So for him to have experienced that type of unruly behavior, personal attack on his person as a judge, and he still went in and returned with a verdict of life imprisonment and not
death sentence.
Give it to the judge, even though he is performing his duty as a judicial officer. So sometimes we try as much as possible not to, just like saying the governor is doing
his job
very well. Yes, he's doing his job. So maybe as Nigerians, let us leave the issue of political solution, because I think the idea of political solution is about seeing that without political solution, that the problem will continue. What problem will continue? Has judgment not been handed down now? All of the stories about if they have said this time to that number that if he's convicted, this Nigeria will be okay. It's Nigeria. Even Trump has not been able to turn us upside down.
Nigeria still stands.
So why will Kanu turn us upside down?
Okay, this is
Thank you very much.
a lot of reactions have been going on since the judgment yesterday, and these words came up again: rendition, extradition. That the way Nnamdi Kanu was brought back into Nigeria. So why does this distinction matter at all in a case like this?
Well, I think his trial is a completely different kettle of fish, if you ask me. Because if, as a lawyer, you are not able to separate the issues from the non-issues, you get entangled in a web of irrelevancies that you make your case complicated. I think the manner of any man's arrest does not determine the validity of the charge.
Okay.
You could be arrested in any manner possible, either judicially or extrajudicially.
But what they are claiming now that he has dual citizenship, that
that's why I say that if he wants to challenge his manner of his arrest, it's a different ballgame altogether.
Okay.
The manner of his arrest cannot be a defense to the charges of terrorism against him. He needs to just face the charges of terrorism and say, I'm not a terrorist.
Okay.
Did he do that? Of course he didn't. They said you are a member of a proscribed group. You don't forget the fact that I think in September 2021, IPOB was proscribed. Another of court. IPOB has not challenged that order of court prescribing it and designated it as a terrorist organization. And he has not also denounced membership of that terrorist organization, IPOB, because as we speak, IPOB is still a terrorist organization by a judicial designation. So if even in court he was still priding himself as the leader of IPOB. So whether he was going to how he was ever able to get over that and even till now is a different ballgame altogether. So his rendition from Kenya to Nigeria, I think that has also been subject of litigation. And there was even a court in the East that gave judgment in several billions of naira in damages for his rendition and all of that. But if you are a dual citizen, right, he still carries the passport of Nigeria. No, the passport of Nigeria. He has not renounced his citizenship of Nigeria. So the mere fact that you are a citizen of another country does not clothe you with immunity from obeying the laws of your first and primary country of origin. So that's the way I would treat it. But again, I also have a challenge with some of our colleagues who sit with clients and they are unable to properly advise a client. The reason why a client secures the services of a lawyer is to be able to tell him what he, the client, does not know. That is why a president has an attorney general and minister of justice. That is why a governor has an attorney general and commissioner for justice. That is why every organization, whether governmental or corporate, has a legal advisor who will look at the entire gamut of your operations and tell you you are acting in accordance with the law or you are acting in variation from the law, and that these are the mitigating factors if you act this way, and these are the consequences if you decide to go right. So for lawyers who have been sitting with Kanu and been part of this entire crisis, and I think that they have not helped him much, because if I sit with you as a client, I will consistently hammer it to your head. This part you are towing has severe consequences.
This was even somebody that shot his lawyers up in the court of law.
I even saw a slap. Yeah. I don't talk, I'm talking, you are talking. That's the heart of professional denigration. That is the height of professional denigration. Even Trump, the most powerful president in the world, the president of the most powerful nation on earth, also takes advice from his advisors, who are the Attorney General, and the entire Department of Justice. And you see that even in the US system, a president can take a decision. The Department of Justice will say, no, this is not supportable in law. Look at the Epstein file, for instance, that was eventually submitted to the US Congress for resolution. Trump has been fighting against it, but everybody has told him, hey, no, that is not the way to go. The law, you owe it a duty. And that is why you have the Supreme Court side him sometimes and rule against him the other time. So there is nobody who is too big to take advice from anybody. If you know that you are unable to take an advice from anybody, then you are essentially digging your grave. So for lawyers who are part of this entire, I saw the way Kanu Agabi and Chief Kanu Agabi and the other senior lawyers walked away with, we have no personal stake in this.
Yes.
Do you understand? Because I'm not sure they would have been able to stay in court and watch the Kanu behave, conduct himself that way. So rendition from Kenya is a citizen of was Simon Ekpa, not a citizen of Nigeria when he was convicted in Finland. Is Ekwe Madu, not a citizen of Nigeria when he was convicted in UK. Was the late Lamasia was not a citizen of Nigeria when he was convicted in the UK and brought back. Ibori was not a citizen of Nigeria when he was convicted in the UK. And there are not several Nigerians that are serving jail terms in Asia, in America, in Europe for crimes they committed in those countries. Simon Ekpa was convicted for his activities in Nigeria, not with what he did in Finland, because the same way he was able to influence the activities of IPOB. And the Finnish court found that, look, your activities were in promotion of acts of terrorism, and he serves the sentence. So holistically, I think mistakes were made, if you ask me, yes. How do we get out of those mistakes? Is it by continuing in the path for which the law has condemned you? No. There must be, don't also forget the fact that the reason the court even revoked his bail was that he jumped bail. And even those who stood shorty, including those who are speaking after this judgment again today, had to come and apply to court to be discharged from being shorties. And these are senators of the Federal Republic of Nigeria.
Okay. The Deputy Speaker, House of Reps, I'm taking you back to the political solution now. Ben Kalu is saying that, okay, they are going to explore political solutions to find a lasting solution to this problem. But then let's look at the mood of the Southeast as we speak after the judgment. Will this judgment put an end to that sit-at-home order usually observed in the Southeast? And what do you think will be the mood of the southeastern part of the country as we speak after this judgment?
Okay, well, first and foremost, I want to just quickly speak to the sit-at-home order, order that has been in place for. I think in recent times that has been toned down. It
has been doused
largely. In fact, a part of that was experienced by us when the Nigerian Bar Association held its conference in Enugu sometime in August this year. In fact, when the conference was originally built to be hosted in Rivers, but as a result of the impasse,
political development,
so the bar decided to move to another state, and then Enugu chose to host us. At first, lawyers were wondering, what are we going to do in that area? Some of us, our family members, are like, what are you going to do in? But we have been there and we have returned peacefully. That also, because some who moved by road had seen what transpired in that environment. So the sit-at-home thing is no longer as effective as it used to be. Even though for some of us, I do not even think it was more of the powers or the strength of Nnamdi Kanu and his people. It was more of the weakness of the governments, over there, so to speak. Secondly, on the issue of political solution and the mood of, I think the question is about the mood. I think
because they have been reacting since yesterday.
For once, we should tell ourselves
the truth.
The truth.
The law is the law.
I think the sense of entitlement. The sense of entitlement, one. Secondly, Nigerians generally, I think, are challenged about having to behave in a particular manner so wrongly that there is no consequence at the end of the day has become the order of the day. So much so that somebody who has done all of this, let us even take the law away first. Let us think as social animals. First and foremost, when you do something wrong, you are meant to be punished for it. Now bring it to the realm of the law. When there is wrong, there must be remedy. When there is crime, there must be punishment. So the laws, the prosecution has presented so overwhelmingly evidence and facts to show that you have committed this and you opted
not to defend yourself.
Not to defend yourself. The legal jurisprudence is very simple. It is either you are in or out. Do you have defense at all? Because even when you bring your defense, it does not in itself mean that it will obviate all of the evidence that has been presented. Now, you didn't even bring anyone
at all.
So I think the mode of the issue should be to look at the realities on ground. And then this attitude of being brainwashed. Okay, while the convention was going on, we were talking about dual citizenship of somebody. He's Nigerian. He also belongs to one other country. The people that we are talking about their mood, a lot of them are just the Nigerians that they are within their local communities. Some have not even stepped to the airport. Some do not even have international passports. But this set of people are the people who have been so brainwashed that whatever this set of people, Samuel Ekpa, Nnamdi Kanu, said has affected the way they behave, the way they relate with even themselves, the way they relate with other parts of the country, to the extent that they seem not to even understand that this is Nigeria, it's not IPOB, not at all.
And it's not a banana republic.
It's not a banana republic. And that will just bring me to some of the people who are Easterners too, who are still shouting that this man must be punished. Don't you think they're happy after the judgment was handed down? At least I watch interviews of Easterners. So
if you say they're happy now, does this bring an end to
this
the issue of Biafra question, or do you think it's going to open something else?
The issue of Biafra, you know, legally speaking, a set of people can come up to agitate.
Demand.
Agitation is different from when you decide to succeed. When you decide to, you know, set up a power, you know, a different set of machinery to activate or you know, actualize, you know, your such tendencies. And this is why we have laws relating to terrorism. In fact, and constitutionally, you cannot even get to the point Kanu is aiming to get to without following the constitutionally, you know, guaranteed procedures. All of that hasn't been done. So it may not end the how do I call it, the agitation?
The agitation, okay.
Because by law, you can still agitate. I can stand up today and say I want Ijebu State. I can stand up today and say I want. Some people want Ibadan State.
Some people want Ijebu State.
But you have to do it legally.
You have to do it legally. In fact, I think they have even presented some of these
to members of the National Assembly.
To the National Assembly. But on your own, leave Nigeria. In fact, let me just quickly digress. The same man jumped bail. Now we are talking about how he was brought back to Nigeria. Yes.
Okay, I'm sorry to interrupt you. I'm actually quoting an elder statesman and convener, National Chairman Igbo Agenda Dialogue, Dr. Chekwaz Okorie, who is lamenting that they told that Nnamdi Kanu life imprisonment judgment will live on the socio-economic life at Southeast is not in the interest of Nigeria. What do you have to say to that?
Gabriel.
You know, my challenge is that democracy has offered us an atmosphere for people to express their views, yes, on several platforms. If you'd ask me, there are even too many groups that tend to be speaking for some group of people, if you'd ask me. And what we must do as a nation is not to take a declaration of self-proclaimed groups as speaking for the entirety of the people, as the expression of the people. The reason I say so is that I'm not too young a man. I'm not also too young a professional. I've by the grace of God be at this level of the profession for a very long time, over 2 decades. I practiced law for over 2 decades and at the highest level, and I'm still operating at that level. I've also read the history of this country. The issue of the agitation by the Southeast, did it start? It's not a discovery by Nnamdi Kanu.
No.
It's not a discovery. Don't forget the fact that this was the reason Ojukwu war, a seasoned army officer, well educated, who has economic powers that he even got from his father. Ojukwu was successful in every right. It was not the declaration of Biafra that made him prominent. He became prominent by reason of his background, his pedigree, his intellect, his capacity to engage constructively and not disruptively, and made him assume the status of a leader for the Southeast, and he was able to convince everybody that we are off Biafra, and the people took flight with him. Eventually, when the chips were down, he also absconded and eventually came back on an amnesty and reabsorbed back into the Nigerian society. In recent times, we have Raf Wazirike, who was the leader of Masob. Masob was the movement for the actualization of the sovereign state of Biafra. Just that at each turn of event, people come up with a different coinage. Nnamdi Kanu also displaced other agitators group and leaders and said they were ineffective. That is going to be the person who will bring about the long desired change. And he set up IPOB.
Brainwashed.
Right? And so if you ask me, those historical issues are still there. But the question I ask sometimes is that are we a joke? If you are saying that the East want to succeed, do you know the number of, for 5 eastern states, you have 3 senators times 5. That is 15 senior senators at the Senate. For some of the states, some of them have up to how many representatives? They are all there. You have 5 governors for each of those states. Are those ones not leaders? Do they actually also want to be out of the country? Every election, we just witnessed an Anambra election. I saw the massive votes that were given to Professor Chukwuma Charles Soludo, who scored about 422,000 votes. Those are Igbo Easterners who voted for Soludo to maintain the state of Anambra as part of the sovereign state of Nigeria. So are those ones also wanting to go? Because if they wanted to go, I would have seen a situation where nobody voted for in that election and say, as Easterners, we don't want to have a government that will represent us in this country. We saw the movement recently of Peter Mba, he's also a colleague, a lawyer, who moved from PDP to APC with such fanfare